Let's talk about private membership associations. So here's my disclaimer. I am not a CPA, tax advisor, attorney, bookkeeper, nor do I hold any degrees that I am not completely transparent about. This presentation is being made while wearing my ministry and PMA advisor hats, and I am not making any legal statements or giving advice, no matter how it may appear. Your presence during this presentation and or watching the replay of it and using the information you learn mean you are agreeing to take full responsibility for your own experience and results. The information shared and discussed is intended for members of Land Bountiful Ministry, and you are agreeing to the bylaws of the ministry now and in the future. For information about what membership includes, you can go to landbountifulministry.org to read the membership application. I am also claiming all rights to this presentation and the content contained herein, including the right to correct errors and omissions now and forever. So I am Angie Taylor. I'm a certified senior PMA advisor, and I have supported women in their childbearing years since 2003. I also obtained 2 degrees in natural health in 2011. Now, I learned about PMAs in 2012. And PMA stands for Private Membership Association. It also stands for Private Ministerial Association, although we have started saying simply PMA/ministry. And the reason that I point that out is that a PMA and a private ministry are 2 completely different things. They function completely differently. And I am going to explain their differences later on in the presentation. Now, I knew one day I wanted to establish my own PMA, and I spent 10 years searching for the right person to support me in this endeavor. During that time, I used someone else's PMA until they chose to dismantle it in 2020. So if one of your questions is, can I just join somebody else's PMA? I really don't recommend that. In 2021, a friend of mine, Amber Sansala, started posting about PMAs and how she helps others establish their own. I attended one of her webinars, had a consultation with her, and established Land Bountiful Ministry in April of 2022. I now guide others through the same process with a specialty in business activities that support birthing families. So today I will share with you the making of important life choices, the hierarchy of laws, where birth service providers fall in the hierarchy of laws, PMA defined, types and examples of PMAs and their differences, constitutional validation of PMAs, transitioning current business activity to PMA, costs involved, what's included, how to get started, and a Q&A session. Before I get into what's coming up, I want to thank the Matrona for giving me the opportunity to share this information with all of you. So this circle represents all knowledge known and unknown. This represents what you know you know. And this section represents what you know you don't know. Now, this larger piece, this remaining portion, represents what you don't know you don't know. So what I'm about to present to you, excuse me, most likely falls within the category of things you don't know you don't know. This information is not new. It is about, it's not about something, quote unquote, brand new thing. It's about something that has been available and hidden. There are men and women who have been benefiting from this information for decades while doing their best to open the minds of others at the same time. As I've already shared, I first learned this information in 2012, and it took me 10 years to find someone who would take the time to answer my questions, to send me credible resources, and walk with me while my mind worked through the cognitive dissonance that had been created. I am offering to be that person for you. Do you know anyone who isn't here because, quote unquote, this does not apply to my country? While the majority of this information will focus on the Constitution of the United States of America, this information does not only apply to those of us living in the United States of America. There are documents, although not as firmly planted as the Constitution of the United States of America, that support this information for everyone around the globe. You are responsible for your own educational journey. Places to start include the Universal Declaration of Human Rights, also known as UDHR. This is a milestone document in the history of human rights, drafted by representatives with different legal and cultural backgrounds from all regions of the world. The declaration was proclaimed by the United Nations General Assembly in Paris on the 10th of December, 1948. It was presented as a common standard of achievements for all peoples and all nations. It sets out for the first time fundamental human rights to be universally protected, and it has been translated into over 500 languages. The UDHR is widely recognized as having inspired and paved the way for the adoption of more than 70 human rights treaties applied today on a permanent basis at global and regional levels. All of these documents contain references to it in their preamble. Canadians also have the Canadian Charter of Rights. We all know there is a right way and a wrong way to do things. We also all know that we can choose to remain ignorant, or we can choose to educate ourselves regarding the realities of the world in which we live. The bottom line is that we all have important life choices to make. Some of those choices are more critical than others. In business, one of the most important choices has to do with establishing a PMA for our business activities or projects, and most of us don't even know that. So let's dive into some information that is vital to understand, especially if you currently believe the answer for midwives lies with approaching the state and or federal governments and asking for specific protections. To understand private membership associations, we first need to understand the hierarchy of laws in the United States of America. So they start with scriptural authority. This includes God's law and natural law. And whether you're religious or not, this exists and benefits you. I'll explain further in a little bit. Then we have the state constitution, and each state has one. The original 13 state constitutions were used in the creation of number 3, the Constitution of the United States of America, which was originally declared by the founding fathers and mothers of this nation. Lastly, we have statutory law as written by the Bar Association. Now, a lot of people today are used to thinking that the federal government of the United States of America is, quote unquote, the top dog in terms of the law. That is actually incorrect. The laws set forth by the federal government are, in fact, not the supreme law of the land when it comes to the United States of America. If you go back to the true hierarchy of laws, our founding fathers and mothers agreed that scriptural authority, which includes God's law and natural law, had authority over all mankind. They knew they didn't want anyone else to experience what they had already experienced, and that scripture, which includes God's law and natural law, was older than all of them. So they started there. It's one of the many things on which they explored and discussed and then found common ground. Now, this is all laid out in the book Original Intent, written by David Barton, which is a great place to start your investigation into why our nation was founded the way it was founded. Then we, the people, created our state constitutions. Each state's constitution is what created each state government. And then the delegates in each of the 13 original state governments created the Constitution of the United States of America using bits and pieces of their own state constitutions, knowing that each state government would have power over the federal government they were creating. Okay, let me Say that again. So each state government knew that they would have power over the federal government that they were creating. We tend to think that the federal government has power over the state, and it's backwards. So the Constitution of the United States is what created the US government, and the US government then created the statutes and regulations known as statutory law, as written by the Bar Association. So why are the laws set forth by the federal government not the supreme law of the land? Well, this is because the created cannot govern over the creator, just like your child doesn't control you and doesn't get to tell you what to do. Okay, so the same is true. Because you created your child, they're not in charge. Therefore, because the states created the federal government is not in charge of the states. And because we, the people, are the ones who created the state constitutions, then your state does not have control over you. Okay. So to understand PMAs, we need to understand the hierarchy of laws in America and where we fall within them. So we have the scriptural authority, again, includes God's law and natural law, and then we have we the people. We were the creator of the state constitutions. And this is really important. So currently it appears as though the spoiled child is holding all the cards. And here's what I mean. The federal government was created by the states as they came together in unity to give specific and limited rights and privileges to it. So the states are the parents and the federal government is the child. And right now, the federal government only has, quote unquote, authority over the states by way of blackmail. Essentially, they say, you will do X or we will not give you money for Y. And instead of figuring out how to accomplish Y on their own, states have been kneeling down and accepting the terms of this deal. Case in point is that one of the rights the federal government has usurped is education. This is not one of the rights nor privileges given to them under the Constitution of the United States of America. The educating of the children created by we the people belongs to we the people. This scenario also seems to be playing out among we the people as we see more and more parents giving authority to their own children that does not yet belong in their hands. We can also see it as we, the people, give authority of our children over to the state by placing them in public schools, which are government schools. The moment we do this, we give away one of our many God-given rights. We, the people, created our state and established a constitution for the same reason, namely to grant our state government specific and limited rights and privileges. Nope. None of you on this call or watching its replay was present when this took place, which is why it is so important to read and understand your state constitution and the Constitution of the United States of America and how and why they came to be. This is because your power under the supreme law of the land is found inside your state constitution, as well as the Constitution of the United States of America. Sadly, our states, instead of turning to we the people to explore and discover how to accomplish why, have sold us out by acquiescing to what they created, namely the federal government. The toddler or US government is essentially running amok and needs to be corrected by the states and ultimately by we the people. You see, human beings do not have power over our creator, God or nature. Therefore, the federal government cannot have power over the states, and the states cannot have power over you because you created them. If this is new information to you, it's because this is no longer taught in government schools. So if you went to public school, you didn't learn this. And it's important to remember that knowledge is power. And without this knowledge, we don't understand the power we have been given by God, that the more than 300 men and women who took time from their lives to secure our liberty by enumerating those God-given rights in a single document. Now, as we go back to living as we the people by relying on our state and US constitutions, We discover, as I've already said, human beings do not have power over our Creator. The federal government cannot have power over the states, and the state cannot have power over you unless you give it to them. Now, as someone who supports women during their childbearing years, you may be wondering where you are in this hierarchy of laws. We, the people, created you, or rather, the need or want of what you do. Because we, the people, are the creator, only we, the people, can grant you specific and limited rights and privileges. Therefore, the state has no power to intercede unless we, the people, add that to their specific and limited rights and privileges. Now, when a midwife or group of midwives asks the state for licensure for any reason, you then become a creature of the state and give your God-given rights away in exchange for privileges that can be taken from you at any time without notice. Then, midwives who have opted in for the state governance known as licensing complain when the state agency that created the license per your request has the audacity to actually govern over you. You gave them permission to do just that the moment you opted in for the license, whether you knew that or not. It is your job to be fully informed before making any choice or decision. It is my personal opinion that there are zero reasons good enough to voluntarily give your God-given rights away to anyone. And to my knowledge, women we serve have not been afforded the opportunity to be involved in the creation of any state legislation pertaining to what we do, and I believe they would vehemently be against it if they truly understood what or that it would mean giving up their God-given rights. There are specific constitutional amendments that protect your right to earn a living and that prevent the state from tying your hands. And because what you do is intertwined with the God-given rights of the women you serve, you cannot hand your God-given rights away in exchange for state-granted privileges without also adversely impacting the God-given rights of the families you profess to serve. Now, I'm going to bring in NARM and the CPM credential because this is also important to understand. The need or want for the CPM credential was not created by we the people. It was created by a specific group of midwives who decided they had the right to develop and dictate what and how midwives needed to learn and practice in order to be, quote unquote, let alone. I'm not saying that what they have set up is bad or good. I'm just saying they made a choice without inviting everybody in because we were not even thinking about midwifery when it happened. So opting in for this path gives NARM authority over CPMs. The CPM's allegiance lies first with protecting her certification, and second is to the families she serves. Protecting the credential will always come first when you are licensed or certified. And we really need to understand that. Okay. So let's chat about public and private domains. So in a properly formed PMA, this allows one to conduct business in the private domain. So you have three domains. You have the private sector, which is your private job. If you work a Monday through Friday, 9 to 5, or any other schedule such as that, that's the private sector. Then you have the private domain, which is where private ministries and PMAs live. And then you have the public domain, which is you're serving the general public. And that's typically how most midwives are practicing right now, is that they're serving the general public. But when you have a properly formed PMA, it allows one to conduct business in the private domain without government interference. You enter the public domain when you create a contract with a state, such as a license and/or business entity. In a properly formed PMA, you have the authority. The government has no access or authority inside your PMA or ministry. This is your castle, and you are the queen or king. This is your private space. The government only has authority in the public domain. When you establish a PMA, that is, an unincorporated ministry or church, you claim additional protections based on scriptural authority. Remember, midwives are mentioned in the Bible, and in one account, a battlefield was completely cleared so they could cross it in safety. Once upon a time, midwives were the care providers for women and children, and it's my opinion that it's time to recreate that. Okay, so again, what is the PMA? I've said private membership association, but what does that mean? Well, what it means is these are formed by men and women who collectively stand and assert their rights to choose for themselves what products, services, or business they will use to live, thrive, and maintain their health and wealth in mind, body, family, and spirit. They remove the ability of local, state, and federal governments to interfere with or regulate your business. This includes removing their ability to demand that you require licenses to conduct your private business. Think of a PMA as your private home. The business that is conducted among family members within the walls of your home is private business unless you are obviously about to commit serious harm or substantive evil. So here are the different PMAs and levels of protection. So we start up at the top with a standard PMA. This is a non-faith-based PMA. These only protect your right to privately assemble and do business in the private, which is still a very big deal. But for most people that I work with, they live their lives according to their faith. And the legal definition of faith is a firmly or strongly held belief. And that's it. So your firmly and strongly held belief could be in God, the universe, Mother Nature, Earth, or it could be in the tree in your backyard. And no one gets to determine if your faith is legitimate or not with a faith-based PMA. Also, with a faith-based PMA, it does protect your private domain. It also protects your ability to invoke your religious liberties. And that's part of your First Amendment rights. Now, both standard and faith-based PMAs tend to be more singularly focused. So basically, if you're a healthcare practitioner, for instance, or if you want to do some kind of homeschool or preschool daycare, you're just operating within that single thing. But if you are a big dreamer like I am, and you have multiple passions that you know are your life's purpose, your ministry is serving others with all of these different things, you're probably going to lean more toward a ministry that's in alignment with your belief system. A ministry is simply when you use your purpose and your God-given skills to serve others. That is the definition of a ministry. And I know traditionally we are used to associating ministries with Christian churches, but that's just not necessarily the case. If you are fulfilling your purpose in life by serving others, that is your private ministry. The benefits of a ministry are numerous. One, you have a lot of breadth and depth to the structure. You can have multiple business projects or activities within one umbrella ministry. You also have the highest level of protection by having the ability to invoke scriptural authority. That goes back to biblical law and ecclesiastical law. One of the other biggest things is you're able to lean on both the case law that protects all of the private domain and all of the case law that has ever protected ministries and churches. So while there's still a plethora of case law that protects the private domain with a ministry, you get to double up on the ministry or on the amount of case law that you can lean on. So there are multiple types and niches within the standard and faith-based PMAs. And you're going to have PMAs. You also have PEAs, which is a private education association. There's also PHAs, which is a private health association. And that's just to name three. Okay. So there's a lot of variety and you can mix and match. I know somebody who has a hotel and they also have an HVAC system. So you don't have to have things that are in the same category. And that's just another benefit. So you can cover all the options under one umbrella if that's in alignment with your beliefs and your purpose. That's why a lot of people end up choosing a ministry. So they can protect, for example, maybe their child's education as well as their interests and activities. So isn't it great to know that our liberty still exists? It's one of the things that I love. All right, so here are some examples. I'm going to give you 5 examples, 2 on this page and 3 on the next, because PMAs are more common than you realize, and they've been around for a really long time. And here are a few of them. So the faith-based associations I just went over, such as churches and ministries. Now, most churches have registered with the Secretary of State under the 501c3 tax code. So the IRS recognizes them as tax exempt. What they did not understand is that by doing so, they are, one, now incorporated, and two, registering as a nonprofit charitable organization, which a church by definition is not. So this is really ironic, since churches by definition and by default in this country already have a mandatory tax exception from regulations placed upon them, which is protected by the 508c1a and 6033A3A tax code in congruence with the First Amendment of the Constitution of the United States of America, as well as the equivalent in each state's constitution. So we just need to remember that from the First Amendment, it specifically said Congress shall make no law, and it means no law, okay? So they didn't technically make a law that churches have to be a 501c3, but if you've ever even tried to read the Internal Revenue Code, it's all double speak. So it's really hard to understand. And they did that on purpose. Okay, so health, wellness, fitness, chiropractic, etc. These members need to sign a private membership agreement to participate. So if you've ever been a member of a gym and you had to sign on the dotted line, and the only people who can come in are the people who have, the card that they can swipe, that is a type of private membership association. Then we have home-based education for parents who want to take charge of their child's education. There are also restaurants who are PMAs, simply because all of the customers are members of the PMA and services issued on a private member-only basis. So for example, the menu might say you are agreeing to membership when you transact with us, and $1 membership fee is included in your order. You may also see a sign on somebody's door. If they're operating out of a premises, they might have a sign on their door that says something like, this is a private member only facility. Access is reserved for members only. You are agreeing to membership when you enter the premises. A $1 membership fee is included in your order. So you don't have to wait until they come in. You give them a heads up at the door. And even if you have people that say, well, I didn't read that sign, that's on them. Right? We all know this from the terms of service agreements that we have to say that we have read and are agreeing to when we make an account on anybody's website. So it's no different when you're going into one of these facilities. If you didn't read it, that's your problem, basically. So this, I'm giving you more specifics on each type. Here we've got the standard PMA. The government has no jurisdiction. Remember, you are the king or the queen of your castle. It is tax exempt if granted by the IRS. So this is not a faith-based PMA. This is a standard PMA. And this is the only one where you will need to speak with a CPA, because its EIN category is a 501A for banking purposes only. You wouldn't have employees in any of these. They would be independent contractors who would claim their income as cash using a Schedule C, or they can come talk to me and I can let you know that income tax, both state and federal, is voluntary. So then we have the Private Health Association. This functions in private and not in public, therefore has no obligation to and immunity from public laws and regulators, including local, state, and federal, and this also includes the FDA. The only exception is if you are presenting a clear and present danger or danger of substantive evil. So this has to be, this is your intent of forming this association. is that your intent is to do harm. I don't know anybody who would do that. But for instance, if someone came to me and said something like, well, I want to start a pedophile association, it'll just be the pedophiles in there. Nope, can't do that. Not at all. You don't get to have one. Okay. Um, the provider may have partnering entities. So you can have one in the public and one in the private. So this does really well for, like, let's say you've got a medical doctor. Well, they have to have a license in order to be able to have prescription writing authority. And so they would have to split their practice basically. And you just have to understand which hat you're in. Um, and so that's something, if you want to ask me more questions, we can have a one-on-one conversation, but I don't want to get into those weeds right now. Then you have a FBA, which is a faith-based association, or a faith-based PMA, or a ministry or church. And this is under the EIN category of 508C1A for banking purposes only. Also, remember, no employees would have independent contractors who would claim their income as cash using Schedule C. They have a mandatory tax exception. Okay. Forming this type of PMA gives you a tax exception. You're not asking for an exemption because you already have a tax exception. Again, there are no employees. You have ministers and contractors. May issue tax deductible receipts to donors. Property can be tax-free, held in the name of trustees of ABC Association and their successors. Then you have the Private Education Association. Parents have a fundamental right to educate children. You have lots of case law here. Here's 3. Pearson Society of Sisters, Meyer versus Nebraska, San Antonio Independent School District versus Rodriguez. You do not have to follow the state or homeschool regulations, just so that you know. Because remember, they've usurped your right to educate your children. If you have any employees, they wouldn't be employees. It would be independent contractors claiming income as cash using Schedule C. So parents can send a letter of intent to the school that says something along the lines, we hereby relieve you of all responsibility for the education of our children, which we are hereby assuming in full. And then you just take over. The constitutional principles that validate PMAs. The First Amendment guarantees freedom of speech and the right to assembly, such as when gathered for a birth in a private residence. It would not apply in any public places like hotels or a hospital or a non-PMA birth center. Then you have a Fourth Amendment, guarantees freedom of unreasonable searches and seizures. The Fifth Amendment, due process must be part of any proceeding that denies life, liberty, or property. Then you have the Ninth Amendment, guarantees certain inalienable rights to every man, woman, and child that have not been enumerated in the previous 8 amendments. The 10th Amendment, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. And then the 14th Amendment guarantees the right to associate with fellow members and to offer benefits and services that are outside of the jurisdiction, venue, and authority of the state and or federal authorities. So I'm going to read some pages from the book Legal Guidelines for Unlicensed Practitioners, written by Dr. Lawrence Wilson. These are from pages 110 through 112. Okay, and I'm going to start with the second paragraph. In Griswold versus Connecticut, the Supreme Court held unconstitutional Connecticut laws that criminalize the use of or assistance in the use of birth control. Justice Douglas wrote that the statutes violated the right of marital privacy created by specific guarantees in the First, Third, Fourth, Fifth, and Ninth Amendments. This opinion by Justice Goldberg, joined by Chief Justice Warren and Justice Brennan, catapulted the Ninth Amendment into prominence. Justice Goldberg wrote that the framers of the Constitution believed there are additional fundamental rights protected from governmental infringement which exist alongside those fundamental rights specifically mentioned in the first 8 amendments. The Ninth Amendment, in indicating that not all such liberties are specifically mentioned in the first 8 amendments, is surely relevant in showing the existence of other fundamental personal rights now protected from state as well as federal infringement. In sum, the Ninth Amendment simply lends strong support to the view that the liberty protected by the Fifth and 14th Amendments from infringement by the federal government or the states is not restricted to rights specifically mentioned in the first 8 amendments. Since the Griswold case, the Ninth Amendment has been cited more than 1,000 times. The most famous case was the Roe v. Wade decision on abortion. The Ninth Amendment was used to support the idea of a right of privacy. Abortion was held to be a private matter. The government could not pass a law forbidding it, even though it might be murder of an innocent child. The early intent of the Ninth Amendment was to protect the states and the people from federal encroachment. The recent use of the Ninth Amendment has been to nullify state laws, especially in the area of morals and sexual matters. I have that underlined because we need to understand that it is possible to nullify current legislation as it pertains to midwifery. I'm, again, not going to go into the specifics because I'm still reading up on all of that. So does the Ninth Amendment protect just any right? Raoul Berger, in the Cornell Law Review, sharply criticized Justice Goldberg for his interpretation of the Ninth Amendment in the Griswold case. Berger argued that if the Ninth Amendment can be used to protect some vague privacy right, what is it to stop anyone from making up a right and then using the Ninth Amendment to protect it? Who is to say which rights will be protected? This is indeed a difficult question. However, one can argue this is precisely the challenge of the law, to evolve as society evolves. It cannot remain static any more than technology, language, or culture remain static. Judge Goldberg and the other justices made their decision by referring to other provisions of the Constitution to establish a framework or rationale for the unenumerated rights. Indeed, a right to privacy has a good constitutional foundation. It also dates back even further to John Locke's theory that each person is basically his own master. Judge Cooley described this right as the right to be let alone. The Ninth Amendment and unlicensed healers. I was unable to find evidence the Supreme Court ever took up the question of whether state medical practice acts violate a right to privacy, the right to associate and contract freely, or the right to protect one's bodily property. Until there is a definitive case, it remains an open question. I believe there is clearly a privacy issue involved in the right to offer and receive one's choice of services in healthcare, education, psychology, and legal matters. Such services may be every bit as intimate and important as birth control or abortion. So pregnancy and birth falls within a woman's right to privacy. Her requesting the support of others falls within her right to associate and contract freely, as well as the right to protect one's bodily property, doesn't it? All right, so let's go over, if what needs to happen in order to prepare for establishing a PMA or a ministry. I don't really like that word preparing because most of these things I recommend people do after your documents have been finalized. So for closing a practice, you make a list of all obligations to parties under your practice. This may include state authorities, suppliers, creditors, insurers, DEA, state licensing agencies, state employment agencies, payers such as Medicaid, TRICARE, etc., referring physicians, hospitals, landlords, accountants, attorneys, insurance carriers, and other parties. You want to notify each of the closure of your practice and the date of the closure. Then you're going to find out how long records must be maintained as specified by state or insurance companies and prepare to file and store them accordingly. Now, if you're closing a business, such as a sole proprietorship or an LLC, you're going to do your accounting and tax reporting. So you're going to prepare a final balance sheet and file a final return and related documents with the IRS. You're going to pay owing taxes. Then you're going to cancel your EIN and business with the IRS. You'll notify customers and all impacted parties. You will finalize employee taxes, wages, deposits, pension plans, and benefit plans. You'll report payments made to contract workers. You'll settle all obligations, and you will finalize and store all records according to legal requirements. You do not ever just allow a license to expire. You tell your state you are dissolving or canceling your license, essentially giving it back to them. So here's a checklist. So you're going to first choose your type of PMA. Remember, you have the faith-based PMA, a PHA, a PEA, or a ministry. And will that be a faith in God ministry or faith in nature ministry? If you have assets or plan to have assets in the near future, then you might consider forming an ecclesiastical trust that operates as a ministry. You then choose the name for your PMA. You need to respect existing trademarks and names. So you would search Google, TESS, as well as domain name registration companies to make sure that you are not stepping on anybody's toes. Then you're going to choose your trustees. So it'd be a chairperson plus one or more additional co-trustees to assist. And if it's just you, don't think that you're out of the picture. Just message me, schedule time, and I can explain to you how you can make it happen if it's just you. Then you're going to inform past and future members. A signed membership agreement is highly recommended. Then, after the founding documents have been completed, you would obtain an EIN for banking purposes only. If you do this before the founding documents have been completed, you have committed fraud, and then you will get in trouble. I don't want that to happen. So what does the cost look like for an ecclesiastical trust plus private ministry is $3,200. Again, this is where your asset protection comes in. And basically what happens here is that your ecclesiastical trust owns the private ministry and all of the assets are owned by the private ministry. Then you have your private ministry, faith in God or faith in nature. It's $2,400. This is the one that's more flexible. It's kind of like an umbrella, so you can have a number of like DBAs underneath it. Then you have a faith-based PMA, which is $1,800, and this is where you can only do one thing. All of these are valid across the United States of America, and thanks to the UDHR around the world. Now this includes your PMA Founders Guidebook, which comes in the form of a PDF as well as a course on my website. You also have a private members only community and a directory listing. So here's my promise: when you allow me to guide you through the PMA ministry creation process and refer others to me, and they do the same, my private ministry, Land Bountiful Ministry, will make a donation to your PMA or ministry. Now, I can also tell you, I'm going to go back to this slide here, what the cost is. Because I can tell you that there are several sources who will happily create PMAs for you that are statutory compliant, meaning that they keep you within the jurisdiction of the current courts and the public domain, which is not where you want to be. And the people who are happy to draft those documents for you will also charge you more. So I just want you to be aware of that. Okay. So the choice is yours. Yes, life does confront us with the challenge of the right knowledge, and the right action is what will carry us through. So the question you need to answer for yourself is, do you want your business private and shielded, or public and exposed. Otherwise, if you want to establish your own PMA or ministry, you would work with someone like me who's a PMA advisor. I do drafting of the founding documents to establish your PMA or ministry. And the reason that this is important is because we want to create legitimacy and structure when we establish in the private domain. And it's not really about, well, is this legitimate or not? It is legitimate. We know it's legitimate, but we also know that everybody's looking for, well, where's your bylaws? Where's your articles of association that tell you how to run your PMA or ministry? So that's what the founding documents do. All that I would be doing is taking the PMA ministry and taking the privacy that you have, similar to what's in your home with your family, and expanding that circle of trust, that circle of privacy, and giving it structure and legitimacy. So now I'm going to go into some frequently asked questions, and then I'll open it up for you guys to ask questions. So the first one is this one: will establishing a PMA keep me from being arrested? No. Okay. Establishing your own PMA will not keep you from being arrested. Absolute protection from being arrested and or charged for anything does not, nor will it ever exist. There's also a big difference between being charged and being convicted. And this is also true when you take on a state license and or certification from an approved organization. So the only thing that can significantly lower your risk of being arrested is for you to carry nothing you do not have the right to carry, do nothing that is known to increase risk to those you serve, use your practice guidelines, contracts, intakes, and consent forms to reduce your risk, know what you need to know in order to serve families safely. If you don't know how to handle emergencies, then please do not serve birthing families until you know how to handle emergencies. And also be honest about your education, skills, and training. Okay. The other thing is to document everything. I know some people who don't have a private ministry who are choosing to not document, as if, well, if I don't write it down, then they don't have evidence against me. But it also means that you don't have the ability to submit something that proves what you did, because you also would need evidence that supports you. So we need to make sure that we are documenting things, and the documentation when you have a private ministry or a faith-based PMA cannot even be subpoenaed. It is private. So what if I do establish a PMA and I get arrested? The first step is remain calm. The second is to claim all your rights, known and unknown. These include the right to remain silent, the right to a phone call, the right to an attorney, and even the right that I claimed early on in this presentation was the right to correct errors and omissions now and forever. That supports people, because, when we're being questioned and answering those questions, we oftentimes get things out of order, we forget something, and that's the kind of stuff that can be used against us. So we want to make sure that we claim that right to make those corrections. Step 3 would be, do not attempt to explain to them that you function in the private domain, because they won't understand what you're saying. And then step 4 is to know who to call. And if I'm the one that drafts your documents, I would be the first person to call. What else can I do to prepare and protect myself? Well, you want to read and study your state's constitution and the Constitution of the United States of America. Watch, listen to, and read anything from Chrisanne Hall. You can start with her non-compliant movie. And number 2 of that is called The Sheriff. I love The Sheriff. I kind of feel like midwives are to be the sheriffs of birth. You can go to libertyfirstsociety.com, non-compliant movie. Then you're going to start reading. And this is not an all-inclusive list. This is just a great place to start. So Making Midwives Legal, Childbirth Medicine and the Law, Legal Guidelines for Unlicensed Practitioners, Fruit from the Poisonous Tree, Cracking the Code, The Fascinating Truth About Taxation in America, and the Right to Earn a Living, Economic Freedom, and the Law. Now, the interesting one of the first one there, Making Midwives Legal, the author was actually setting out to prove that regulating midwives is beneficial. And much to his dismay, he discovered that it was not beneficial. It was making things worse. It's a really good book. States with licensure have defined midwife. Does that mean I cannot refer to myself as a midwife? We first have to know to never assume that you understand the words being used in any form of legislation. Okay, if they have, when you are reading a piece of legislation, if you see a section that says definitions, read the definitions, because those are custom definitions. And when a custom definition is used, such as for midwife, it changes the word to a term. We must recognize that if a word is meant to be understood as having its common meaning, there's no need to define it at all. And it is axiomatic or self-evident that if a word is explicitly defined, it has a restrictive meaning. So a custom definition means the common meaning of the word must be excluded. I think that's really important. I think sometimes, we get all stressed. Oh no, they've defined the word. And then we read it, we're like, well, that's not how I function. But does this still apply to me? No, it doesn't. It actually excludes you. So this is the term that it goes from. This is from Black's Law Dictionary, 6th edition. Inclusio unius est exclusion alterius. Practice this all day long. The inclusion of one is the exclusion of another. The certain designation of one person is an absolute exclusion of all others. This doctrine decrees that where law expressly describes a particular situation in which it shall apply, an irrefutable inference must be drawn that what is omitted or excluded was intended to be omitted or excluded. And yes, you're probably thinking, I got to become an attorney. No, you don't. But there are some things that you need to understand. This is an educational process. What about the recent call for midwives to join together and seek federal legislation for traditional and indigenous midwifery? This is the wrong direction. We need to learn how to secure our rights that are enumerated in the Constitution of the United States of America. We need to understand the Constitution for the state in which we live, and we need to stop operating from a place of fear and come to understand the foundation on which we already stand. The founding fathers and mothers of this nation expected us to absolutely rely exclusively on the Constitution. They included an amendment for the God-given rights they hadn't specifically listed. We, the people, have those rights unless we choose to give them to the state or federal government by doing things like asking for legislation to quote unquote protect us. The entire goal of the founding fathers and mothers was to do the very best they could to create something that would protect us from government overreach. Sadly, we've come to a place where everyone seems to think that the state and federal governments need to legislate everything under the sun in order to protect us, without understanding that when we do that, we give away our God-given rights and exchange it for permission and licenses that can be revoked, pulled, and canceled at any time. The fact remains that most of us don't even understand that licensure in and of itself is government overreach when it comes to all the things related to birth. So stop inviting the state and federal governments into the family bed. Let's remember too that the protections for midwives goes back further than the founding of this nation. We have biblical roots, and that matters in every nation on the planet. What we do predates every government ever created by humans. Yet, so many are still seeking for someone outside of them to tell them what they do is legitimate. The fact is that the man-made baby delivery system needs to prove its legitimacy to midwives because what we do came first. Okay? So, who is the man-made baby delivery system? Sadly is not just the hospital. When we buy into the fact that birth and everything related to it is medical, we become part of that man-made baby delivery system. So do you know that just because someone like a midwife gets charged with something, it does not mean she cannot provide services to others while she's being investigated? Do you know that it's also not her job to help with the investigation? Do you know that even if a state agency sends a cease and desist letter, they still have to have jurisdiction before the letter is valid? And do you understand jurisdiction? And it's okay if all of your answers to those questions are no. It just tells you where you need work, where you can go and study. And I'm happy to be that go-to person and say, go here, go there. But it's also good to start diving in on your own. So how do I protect myself from being arrested for practicing medicine without a license? Okay. One of the hurdles we all face, regardless of where we live, is that the practice of midwifery is not the practice of medicine because the normal, natural, physiologic process of a woman's body is not medical. And the state of Kansas's Supreme Court agrees with me. I believe that this case goes back to the 1996 or so, but you can look it up. All of these rulings are a matter of public record. This is the State Board of Nursing and State of Kansas, State Board of Healing Arts versus E. Michelle Rupke. So essentially, what the state of Kansas has is that anyone in the state of Kansas who supports a pregnant or birthing woman cannot be arrested for practicing medicine without a license because these processes are the normal, natural, biological, and physiological processes of her body. Now, this does not mean that those same people cannot be arrested and or charged for something else. Okay, they're just protected from practicing medicine without a license. And it is my personal opinion that those processes should not be covered by medical insurance. And therefore, there should be no medical codes for those processes either. So you might be thinking, well, what about, fill in the blank, all the different ways that birth can quote unquote go wrong? And my answer to those questions about when the normal is no longer normal and is not responding to things like nutrition, increase in salt, rest, etc., then and only then does it become medical. Then we transfer care for the benefit of the woman because her body has proven it needs what medical providers offer. All things related to birth seem to come down to an education problem and unwinding the things that have been put in place by those who have little to no knowledge about the normal, natural, physiologic processes of a woman's body, because they deal primarily with the instances when those processes are no longer normal. So, in essence, we are talking about the same topic while speaking two separate and distinct languages, and that's important, okay? I think that midwives want to talk to OBs and OBs, at least some of them want to talk to midwives, but we first have to find that common ground because we are speaking separate and distinct languages. Midwives, we are talking the language of physiologic, and OBs are typically coming from the language of not normal. And we've got to find the middle ground in order to have a truly helpful and collaborative conversation. So what about state mandated tests and screenings? If you have a private ministry, how do you do those? Well, in state legislation that makes these things mandatory, it's important to confirm first whether or not there is a parental opt-out clause found within that piece of legislation, because there are some states that do have a parental opt-out clause. I personally have chosen to no longer offer the things like the PKU test, simply just for my own personal reasons, the things that I have learned as I have gone through this process of being a midwife. And I simply explain to the families who interview me my personal whys behind the decision, and that if they want it done, they can have a pediatrician do it. I also encourage them to do a lot of self-educating on the topic because the child's DNA does get stored when there's enough of the blood sample left over after completing the PKU tests, and the parents haven't given their consent for that to happen. Okay? They didn't sign anything giving that consent that I'm aware of. So they need to know and do their due diligence, even on what is the PKU? What are these things that we're screening for? How common are they? How rare are they? Okay. What about submitting birth certificates? Okay, so as far as I know, paper forms are still available when it comes to submitting birth certificate paperwork because home birth in and of itself is legal and lawful in all 50 states. The only person being regulated in most cases is the midwife. The paper form is also how unassisted families submit the form. Now, it may take some states longer for them to input the information from a paper form into their system so that the families order for a copy of the certified birth certificate can be processed. And that is a state problem. That there's nothing that we can do to fix that. But she can still go out at 6 to 8 weeks post-birth and she can place that order and she will receive it when the certificate is ready to be sent. Also, if you are already practicing in the public and you already have access to the state's digital submission platform, assuming that they have one, you will, in most cases, continue to have that access. And the reason I say that is because there's no reason to notify them and say, hey, I now have a private domain business. I don't have an LLC anymore. They're not going to know that. So there's no reason to tell the state or anyone how your business activity has been established. Okay. We just, for some reason, we get into this private domain and we have our PMA and we have our private ministry and we just kind of feel like we got to tell everybody, oh yes, this is, but it's totally unnecessary. They don't need to know that. The only person that needs to know are the families that you're serving. What about obtaining clients and transporting to the hospital? I recently got this question, and it's not the first time that I've been asked, so I thought that I would add it. So for me, I'm very honest about how my practice has been established and that the practice of midwifery is not, nor will it ever be, the practice of medicine. I explain all of the things that I can do if they'd like to have it done, such as blood pressure, urinalysis, ordering blood work, sonograms, all of that, and that their entire chart is private. We even talk about what documentation, if any, they would give permission for me to hand off to a hospital should there be a need to transport. And they sign a form that gives me their written permission. I never try to explain to any medical person anything about the private ministry. It will just sound foreign and illegal to them. And like I said before, it has nothing to do with why the transport happened. So the main difference in how things happen between now and before establishing the private ministry is that each couple must read, initial, and sign the member intake waiver form. Okay, because that explains all about the private ministry and it lists out the things they need to understand and agree to. I do not serve any family who will not sign the form. This is what protects both parties. I make sure all their questions are answered before they sign. And I have had very little pushback on this, especially once they realize that the documents make everything a private matter. And it makes it much stronger than any privacy policy found in the public domain. I really look forward to seeing each one of you in my email inbox wanting to set up a consultation because I would love to at least have that conversation where you can get more personal and questions answered that are unique to you and your situation answered. So if there aren't any other questions, I'm going to go ahead and end this call, but you guys know where I am. And here's my email address. If you haven't snagged it yet, go ahead and write it down or take a screenshot so that you've got it.